Hitchcock Cross talking to you today. We're gonna get some more progress done, if not finish. Novak here. I appreciate you sticking with me in these bite-sized samples. Yeah, it's a lot of content to get through. So we're gonna get to that. I just want to pause here, and I do want to echo a word that somebody said, which was the fence was not improperly installed. It was properly installed. That is to say that the warden in 1986, I put out a public records request for his name, by the way, but that slipped through the cracks. I assume it's a him, based on the facts that we have. Yeah, so why did he do that? The testimony is essentially to injure escaping inmates because they weren't going to have any of that namby-pamby stun fence stuff. They wanted people to remember, that they had been in a fight after they had gotten through the razor wire fence. So that is absolutely 100% correct. That is the reason that fence at Columbia is in the position that it's in, and for no other reason. It was a deliberate choice. That was, I think, I brought this to the attention of many media organizations, including ones who supposedly specialize in muckraking news for Wisconsin, handed it to him on a silver platter and said, look, here's evidence. Here's this guy, this former administrator testifying. Why don't you call him up and ask him about the status of this fence and why it was put in the way it was put in on purpose. Let's be real clear with that. On purpose. Okay? And so, it reminds me of something that my daughter once told me when I was goofing around and threatening her. It told her something around the lines of, I take that back on the threatening, but it'll sort of give you an insight here. I told her that accidents will happen, And she turned around and looked at me and said, on purposes will too. And I think that I do not need to share too much of my family and all that on this channel, and certainly that is not meant to burst that bubble. But there's nothing like a daughter telling you that on purposes will too. That'll make you sit up and think a bit. So that's, I think, important context for all that, and it's very important to know that this was a deliberate choice. And the female is being punished for this deliberate choice here. And the reason for that, in my opinion, is because Carr cannot be held and Fesahaya cannot be held responsible, even though they knew they should have known. And it's that if you want to look at it from a psychological analysis, just my analysis, just my opinion, their guilt at having failed because they don't know how to do their job. Because remember, he was just the chief deputy, Milwaukee County. That's definitely an important position, but not the same position. He was then worked for the Marshal Service, not the same position by any stretch of the imagination, not really an administrative position. And I can tell you that the Milwaukee County is just on a completely different order of magnitude than the Department of Corrections. It's just incomparable. Meaning it's like Keystone Cops, it's penny ante. Nothing personal against them. They do have a large and significant organization, but it's the comparison here. Then we take Magda Fesahaya's only experience, which was to be a HR attorney. And then an HR functionary before that. And then all of a sudden she's jumping all sorts of precedent and never having run an institution or having any knowledge of what they're, never having actually even been and looked at the walls there. So, and remember, to me, that this quote is not in this decision says more about the quality of this decision, I think, than anything, which is Miss Fesahaya saying, all I know is that I didn't know anything about the fence. I don't think that statement in and of itself, divorced from any context, is tautology. I mean, it's a fallacy. How can we put it? I mean, it's preposterous on its face. So that's my little introduction on that. Let's keep going through the misery. I do want to say here that there is going to be so much shade thrown at yours truly, if there hasn't already been, with, so heretofore, as we might say. And, there's going to be comments on my argumentation, my grammar, my diction, my means of lawyering, my means of eating asparagus, I'm sure will come up. Nevertheless, little Woodhouse reference for you all. Nevertheless, I'm just stating here, we're going to, all warts and all, we're going to look at all of it. Hey, here I am. Let's do this. Bam. On June 23, Novak was still on paid administrative leave when Novak was given a letter from Internal Affairs investigator Joseph Sonnenberg, scheduling Novak for a pre-disciplinary meeting on June 25th at noon. Subsequently, the pre-hearing disciplinary meeting was rescheduled to June 29th. Both notice letters informing Novak of the pre-disciplinary meeting contained the same information about the possible rule violations that Novak was facing. Novak was informed in the notice that she was being given the opportunity to refute management's findings, introduce additional information, facts, or evidence not yet presented to management for consideration in making a final decision regarding whether disciplinary action should be taken against Novak. And so, in order to believe that that's true, that letter may have said that, but the real question here and the real analysis this judge needs to make is whether or not that was a factual statement. Because it is true that that letter contained those words, but really the question and the hard work that had to be made was who was making that decision. Had the decision already been made or something else? And I think that really is the question that there's no attempt to answer. The letter informed a preliminary decision, The letter stated the specific issues involved Novak's failure to inquire about fixing the stun fence, Novak's failure to ensure the EMC Monitoring Center and the Office of Victim Services and Programs, and again, OVSP, in case you didn't get it the first 8 times, were notified about the inmate escape at CCI. The letter also stated that despite having multiple sources of information about a staff member's misconduct, Novak did not place the staff member on administrative leave. You sort of wonder if the repetition is purposeful, and if so, what is the purpose? Just from both, a grammatical standpoint, from a communication standpoint, from a decision that's given out on the last moment of before your retirement standpoint. What's the purpose of all this? I'm asking you. All right. The letter also stated that despite having multiple sources, yes, Novak did not do that. After receiving the notices of pre-disciplinary meeting, Novak was concerned. Okay, this is for people who may or may not be named. Julie out there. Fingers crossed it worked. Was concerned because the charge of serious misconduct was a charge that could result in the termination of Novak's employment, even though Novak had never been disciplined. Well, and the comments from Kevin Carr about firing her if he got half a chance to do it, and the statements from Swatchert, and the statements from all the other male employees, and the statements about her being emotional, just for starters. The treatment that she got that other people didn't, how she had to get male wardens to mail-splain to Carr. All of those factors too. You do not, we all heard that testimony, but you do not see that in here. Okay? And you have to keep in mind that the judge is the one who can find the facts. She does have that power, so she can select what things to put in, what things to put out. She's constructing this reality here. But with the fact that it's her boss, among other things, that is one of these actors, and the way that she communicates about her boss, we don't even need to get that far, but it is telling when you look at it through that lens. That's, I think, something everybody needs to keep in mind. Okay. During her 30-year career with the DOC, Novak contacted, and so you might think the fact that Novak had never been disciplined during 30 years would go to the fact that these serious misconduct charges were out of whack and pretext, but instead it's used as evidence that Novak somehow knew about these charges, serious misconduct charges could result in termination, even though she had never been determined. How about the fact that she was a warden? Because that's what she testified, how she knew that. How about that fact? 30-year, Novak contacted human resources employees to find out what would happen to her benefits if her employment with DOC was terminated, what would happen if she retired. Novak found out that if her employment with DOC was terminated, then she would keep her retirement pension and her accrued paid leave, but Novak would lose the benefit that allowed her to convert her sick leave balance into cash to pay for health insurance when she retired. However, if Novak retired from her employment with the state during the investigation, Novak would be able to keep her pension, her accrued paid leave, and the conversion of sick leave to pay for health insurance. About, she said, somewhere up north of $300,000. Okay. Since Novak provided the health insurance for her family, Novak decided to retire during her pre-disciplinary meeting rather than to take a chance that she would be terminated after the pre-disciplinary meeting. At the time that Novak made the decision to retire, she was on paid leave, receiving her full salary of $107,000 annual. That's like not even half of what a superintendent at Milwaukee Public Schools makes. It's not even a third of that. Man, those chumps at the wardens really got to get their acts together. And, I mean, geez, Louise here. All right. She made the decision to retire, okay? That's going to tell you where we're headed because there we go. That doesn't sound like constructive discharge to me. She's going to explain the analysis, but the facts that she constructs are going to tell the story. On June 29th, Novak provided a written pre-disciplinary statement and a verbal pre-disciplinary statement responding to the rule violations that were listed in the notice for pre-disciplinary meeting that had been given to her. Novak gave a lengthy discussion of her reasons for her belief that she was not being treated fairly in comparison to the other employees, particularly male employees. Oh, okay. Hey, let's just notice here how whenever it's the state doing something, it's passive, but when it's Novak doing something, it's active. We get that sometimes a lot with, the state and criminals, or the state and, it's just always employees for me, but we can see a grammatical shift, in other words. That's what I'm trying to say, that their own words, I think, tell us where they're coming from more than they would like. Novak compared her treatment to other male wardens who worked for the DOC many years prior to Secretary Carr and DAI Administrator Fesahaya being in the position. What a jerk. Why she would suggest such a thing, that there was any continuity in a governmental corporation? That's outrageous. I think she should probably be in jail among anything else that she gets coming to her, because what a jerk. And her discussion was lengthy. No manners, not Wisconsin nice. All right. About statements that had been attributed to Carr during the January 26th advocacy meeting. Oh, did you see that? Had been attributed to Carr. Come on. About allegedly being willing to terminate Novak and other employees if they broke the rules. And where did the other employees come from? Did somebody check that for me? Because I would appreciate that. Other employees. That's okay. Complained that she had asked for guidance from her male supervisor, Percy, about whether to place an employee on leave, and Percy made Novak make the decision, and now Novak was being investigated for misconduct, but Percy was still working. Novak also stated that the sun fence had been improperly installed in 2006, and 3 male wardens had not asked for it to be repaired during the period from 2006 until 2018. Novak noted that she was told that she had been doing a great job at CCI when she was told that she was being reassigned to be the warden at Red Granite. Novak stated that she had never received any discipline or poor performance review in the 30 years she had been working. Novak argued that she was not being given not being given due process because Carr was trying to satisfy an advocacy group that Novak believed had demanded that she be fired back in, or had demanded that she be fired back in 2019. I mean, why say that Novak believed it when the evidence is just clear that that's what they said? And why fight so hard to try to keep that out? Novak stated that she believed that ethically Carr and all those within his jurisdiction, including Deputy Secretary Petchacek, should have recused themselves from making any decisions regarding Novak because Carr's conflict, because Carr's desire to satisfy the advocacy group. Novak stated that she was retiring under duress effective immediately due to the unfair treatment that she had received. On June 29th, Novak's working conditions were not so intolerable that a reasonable person would have believed that Novak had no choice but to resign. At that time, Novak resigned. Novak was on administrative leave and being paid her full salary. And while receiving the employment benefits that she received while working, Novak was expected to stay on paid administrative leave as she waited to see if she would be found to have violated work rule violations and what, if any, discipline she might receive, or if she would be exonerated of any misconduct. When Novak retired, Novak made a calculated decision to protect the benefits that she had rather than risk losing her sick leave conversion benefits if her employment was terminated sometime in the future because of her conduct in connection with the investigation of the inmate escape at CCI. So that's where we're going to wrap it up today. We're going to need, this is going to be a very important paragraph. We're going to need to keep it with us when we talk about later on. We're going to read the case and go through it here. The question of what is constructive discharge. And there's no question that it's an uphill battle. But the words here, basically, it's a situation that's so intolerable that no reasonable employee, which means a judge, would feel that they were forced to resign. Okay? A situation that's so intolerable that a reasonable employee, meaning the judge, would feel that it was a situation so intolerable that they would be forced to resign. Okay? Now, we have to understand that this judge here has only worked, I assume, for the state of Wisconsin, or, for the vast majority of her life. She certainly was an ALJ. I think one of the original ALJs, back in the 70s, 80s when the ERD was first developed. So I may be wrong about that, but we're going to stick with substantially all. That's her experience. Okay, she was basically never been in a position to ever be terminated or even disciplined for even, pretty much overt misconduct. Okay, there's several cases out there when it just explains that she does misconduct, and instead of she dismisses a case twice for no reason, and then the LRC sends it back twice, and then on the third time they say give it to another judge, who, by the way, adopted all of her findings just as a courtesy to her. And LRC said, what the hell, there's no courtesy. What are you talking about? Due process does not involve, to this complainant, does not involve courtesy to another ALJ. No part of due process. So that's something. So that's the real question here. We're not going to go into the standard more than that, but do you feel that paragraph 73 presents a situation that's so intolerable that a reasonable person would feel forced to resign? That's the question. I put it to you. Now, hopefully, we can do some... J-E-L-L. You got both there. All right. So, hey, I love this. I hope you do too. Stick with us here. This is employment law. This is the nuts and bolts of let's say there's a better word than cow patties, but this is how the sausage is made. So this is why I enjoy sharing it with you, and thanks for sticking with us. We'll keep you informed. All right.